this panel. I'm Mark Levin. I'm Director of the Center for Effective Justice at the Texas Public Policy Foundation, and also one of the leaders of our Right on Crime initiative, which y'all may be familiar with. And today we're here to talk about the issue of overcriminalization, particularly but not purely as it relates to ordinary business activities that are increasingly coming under the rubric of criminal law, both in this state and throughout the country. And I'll tell you, one of the interesting quotes that I think we should keep in mind in this discussion was by the head of the police, secret police under Joseph Stalin, who said, "Bring me the man, I'll find the crime." And that really epitomizes the difference between a tyranny and what we would like to have, which is the rule of law and limited government. And obviously we need criminal laws, but we need a limited number that are clear to the average person so one has fair warning and can make sure to bring one's conduct in compliance with the law, and that there are not so many laws that are so vague and overbroad that any prosecutor, and Shannon would be the first to tell you the vast majority of prosecutors are well-intentioned and wouldn't try to do this, but that any prosecutor, if they were so determined, could find you guilty of some criminal law somewhere. So that's really what this issue focuses on. And here in Texas, we have about 1,700 criminal laws on our books. We actually counted them several years ago. Thankfully, an intern did that. Our intern now for our center is sitting right here, so I'm not going to announce that we're going to update that list tomorrow, but maybe we should. But about 1,500 of those 1,700 criminal laws are outside the penal code, which means they don't deal with stealing, murdering, raping, those things that are traditionally inappropriately criminal. Rather, they're scattered throughout the agriculture, business and commerce code, and so forth. So we have 11 felonies, in fact, just relating to harvesting oysters. Now, we haven't looked at every state, but it seems like we've got more criminal laws than the average state. We also, as Chairman Caligari will tell us, we license more occupations than the average state. So, of course, in Texas, we pride ourselves on small government, but in these areas, we're really not smaller than average. And the reason licensing, of course, comes into this is there are a number of criminal laws that say any violation of an agency's rules is a Class A misdemeanor. We have a number of those statutes in Texas. And so, of course, that includes violating some agency rules when it comes to licensing, licensed occupations. Now, this issue is finally getting a lot more spotlight this year, and I think it's largely due to the raid on Gibson Guitar in Tennessee, which many of you may have heard about, the police for the Environmental Protection Agency, and there's a growing number of police forces within each federal agency. But they raided Gibson Guitar, confiscated a lot of wood that they allege was imported improperly. And in fact, there's the first hearing in this case is on January 30th. The CEO of Gibson has actually signed on to the Right on Crime Statement of Principle, so we're very pleased about that. But this is really drawing attention to this problem. And one of the other things I think that there's increased attention on is the issue of mens rea, which for those of you who are not familiar with that Latin term means a guilty mind. And traditionally the definition of a crime is a bad act plus a guilty mind. But we've seen the erosion of mens rea. Many offenses now strict criminal liability, not even having to prove that someone was negligent. So we actually filed an amicus brief in a Florida case this year that involved their drug statute. And the issue is their drug statute says no level of culpability is required for conviction, no mens rea. And so that means if you were to rent a car from Hertz in Florida and you had no idea there were drugs where the spare tire is supposed to be, you would be guilty under strict criminal liability because it didn't matter that you had no intent. And so a federal judge appointed by President Bush struck down that law, and it's now before the 11th Circuit, and we filed an amicus brief not in support of illegal drugs by any means, but in support of this concept of mens rea. So we have a great panel here to discuss some of these issues and share their insights with you. And so I will go ahead and introduce our first speaker today, which is Tim Lynch. Tim Lynch is at the Cato Institute, a free market think tank in Washington, which does tremendous work, which I'm sure many of you are familiar with. And he has been a voice on this issue throughout the country. He's testified many times before Congress on overcriminalization. In fact, when there was one or two overcriminalization hearings in Congress about a year ago, I believe it's the first time Congress ever convened a hearing to ask the question whether we have too many laws rather than whether we need more. And so it was a historic hearing, and there is significant interest on Capitol Hill in this issue. And Tim has drafted numerous articles and studies for the Cato Institute, which have greatly contributed to awareness of this issue and also highlighting some key solutions. So he's going to talk to us, give us the national perspective and the philosophical backdrop to this discussion. So please join me in welcoming Tim Lynch.
Thanks a lot, Mark. I do appreciate the invitation to be with you this morning. You're right that the subject of over-criminalization of our law has been getting a fair amount of attention over the past year. As Mark mentioned, last month, the House Judiciary Committee in Washington, D.C. held a hearing on federal code reform. A few months before that, Yale Law School held a small conference on over-criminalization. And for those of you who read the Wall Street Journal, you may have noticed that they have run a series of articles over the past year that have highlighted the problem of over-federalization and over-criminalization of the law. And one of the articles was about the raid of the Gibson Guitar Company. What I want to do this morning is highlight what I think should be some of the key principles of criminal law reform that would apply not just to federal criminal law, but also to state and local laws. But before I do that, I do want to stress that those of us who deal with the law, whether it's in the law firms or in the assembly or in the Congress, those of us who are in the legal field should not lose sight of the fact about how the application of the criminal law affects the lives of real people. I mean, we are talking about the rules by which people in our communities can be arrested, indicted, and sent to prison. Even in situations where people are not convicted in a court of law, still the application of the law can alter their people's lives forever. All it takes is a single raid that's highly publicized on the evening news, and a business can go under. Just for some people, just getting arrested, it might end their career without, again, having to be convicted in court. Even in situations where people are able to win their case in criminal court, the financial burden involved these days of mounting a legal defense in a trial can break most families. So with that background in mind, let me talk about, again, what I think are some key principles that ought to guide reform in the criminal area. First, there is the basic problem of over-criminalization. There are so many rules on the books nowadays, as Mark was saying, at both the federal and state level, that the old legal doctrine that you have heard of, that ignorance of the law is no excuse, I mean, this doctrine just does not make sense anymore. I mean, we could spend all of our days and weeks reading and studying the law, and we would not get to all of them. So this doctrine, which arose in a situation where only those basic violent crimes were on the books, about murder, rape, theft, fraud, assault, that doctrine made sense for a criminal code that was limited to those basic offenses because it was inherently wrongful conduct. But when you start to expand that doctrine of ignorance of the law is no excuse over to the regulatory area, it just creates all types of injustices. In my book, I discuss an example where a man was prosecuted for a firearms offense, and his purchase of the firearm was totally lawful. But years later, in a divorce proceeding, he was supposed to surrender that firearm. But the problem was he didn't know he had to surrender it. There was a divorce proceeding that started, there was a restraining order that was issued, and under the law, he couldn't possess firearms anymore. And he was prosecuted because he kept his firearms. And his legal defense was that his own attorney didn't advise him that he had to surrender the firearm. The judge in the case told him, didn't tell him that he had to surrender the firearm. And if you looked at the restraining order itself and its terms, didn't say he had to surrender his firearm. So he's like, I was never put on notice. But the prosecutors in the case just shrugged and said, ignorance of the law is no excuse. 3 years in prison for that offense. Over the holidays, I read about a case of a woman from Tennessee who had a valid concealed carry permit, and she was in New York City over the holidays, and she was at Ground Zero, and she saw a sign that said no firearms in the area, so she went to a security guard to check her firearm. Instead, they placed her under arrest because she didn't know about the strict firearms law policies in New York City. Again, there's no evidence. No one really thinks that she had any, mischievous intent or malevolent criminal intent involved. But with these rules that are very strict, you can be arrested and prosecuted. What I think needs to be done is that we have a criminal standard in place in the tax area that I think ought to be the model that we should follow. Everybody here knows how complicated the federal tax code is. Right now, though, the standard is in place for those people who honestly try to get their returns right but want to avoid accusations of tax evasion. The legal standard is that the prosecutors would have to prove a willfulness standard, which means they have to prove not only that somebody got their tax return wrong, but they have to prove that the person knew what the law required and then went ahead and violated it anyway. That's the standard they have to prove in court to make a case for tax evasion, not simply that the tax return was wrong. We have to get this willfulness standard expanded not just for the tax area, but for all these other regulatory rules that are in place to protect people who are honestly trying to stay in compliance with the law. The second principle that I want to highlight, again, is kind of related, is that the line that separates the conduct that is lawful from conduct that is criminal needs to be very clear and not fuzzy. You see, even if the overall volume of the criminal laws is scaled back, we still have a serious problem if you sit down with the remaining rules. If you read them, you still can't figure out, because it's vague, what conduct is lawful and what conduct is unlawful. And that line just needs to be darn clear, crystal clear. Now, to remedy this problem, I recommend that states like Texas codify what we call the rule of lenity. Lenity is a legal doctrine that the courts use sometimes, and it says if the law is ambiguous, we're going to give the benefit of the doubt to the citizen, not to the prosecutors. Now, the problem is the courts are applying this rule of lenity sporadically. They apply it in some cases, but they don't apply it in other cases. Now, those of you who went to law school might remember that there's a similar legal doctrine in the area of contracts. The doctrine there is that if the terms of a contract are ambiguous, you're not sure it could go either way, they're going to resolve the ambiguity against the person, party, or organization that drafted the contract. And the rationale there is that they were in a better position to make this issue clear because they were drafting the language. So they're going to resolve the ambiguity against the persons who drafted the contract. It's a sensible rule, and if we have this rule in place for contracts, we should be having the same rule in the criminal law where the stakes are even higher. But as I said, there is a rule of lenity. The courts apply it sometimes, but not others. We need to have Texas legislature codify this rule so it applies across the board. Some states, like Pennsylvania, have done this, and it's the right way to go. The third principle that I want to highlight is that we need to stop this idea of agency rulemaking. There are way too many regulatory agencies out there that are promulgating their own rules that have the force of law and that carry criminal penalties. There's an important principle at stake here. Really, only elected officials accountable to the people should have the ability to create positive law that can serve as the basis for a criminal conviction. And again, criminal laws that carry possibilities of people going to prison. Now, I know elected officials are very busy. They're always being pulled in different directions to address this matter and that matter. But it's hard for me to think of a more important responsibility than attending to the rules by which people's reputations can be tarnished and where they can actually lose their liberty and go to prison. Now, one of the arguments that we hear on this subject is that, well, certain agencies, like an environmental regulatory agency, they develop some expertise in a certain area of the law. Well, that may be true, but the answer is that, okay, they can send their recommendations over to the legislature. If they think that we need certain new regulations in place, send their recommendations over to the legislature, but that's where it needs to be voted up or down by our elected officials. To have these agencies out there just promulgating regulations on their own without elected officials approving them is just wrong, and we need to put an end to that practice. The fourth principle that I want to highlight is the idea that it is wrong to punish one person for the actions of another. Now, this, for a long time, was a fundamental principle of American criminal law. You're responsible for your conduct. You're not held responsible for something somebody else does. But we've been drifting away from that principle. Last summer, the Washington Post reported on a case involving the Securities and Exchange Commission. It was an enforcement action against the CEO of a company. There was some accounting fraud going on at this company, but it was being done by some mid-level executives that were trying to enrich themselves. Now, here's the thing. The SEC acknowledged that the CEO of the company was himself a victim of the fraud because he was not aware of it, did not approve of it. He actually did an internal audit of the company because something didn't look right in the books. So he was one that actually discovered the fraud that was going on. And nevertheless, for reasons I cannot fathom, the SEC is still doing an enforcement action against the CEO to forfeit bonuses that he had received, punishing him for the actions of other people within his company, actions that were totally unauthorized. Now, state and local officials are also doing a little bit of themselves in a different context, the context of civil asset forfeiture laws. These are laws that allow law enforcement to seize cash, cars, boats, home, land, from people who have not been convicted of a crime. Now, just a little background on this. There are two types of forfeiture. There's criminal forfeiture. Now, this is where somebody has been convicted in a court of law for a crime, and then the police seize contraband, stolen property, ill-gotten gains. There's no problem in this area. The person has been convicted in criminal court. The second type of forfeiture is civil forfeiture, and this is the problem area. This is where the state can take property away from people who have been not convicted of a crime in court. They don't even have to be arrested. The Wall Street Journal reported on a case where the police and prosecutors are trying to seize a hotel business that was located on 20 acres of land. And the family had been in this building up this hotel business for over 30 years. See, the police arrested some guests of the hotel who happened to be selling drugs out of the place. There's no evidence at all that the owners had any involvement in it whatsoever, and yet law enforcement is still initiating this action to seize the hotel and to seize the land on which it is based. The couple had been planning to sell this family business in 6 or 7 years and use it to finance their retirement, but now their nest egg is in jeopardy because of this legal action. So this is what I mean about the law punishing some people for the actions of another. And this is an area where, again, Texas law in the civil forfeiture area definitely needs some reforms there. Now, I'm just about out of time, so I better stop with a final thought. The good news is that more and more people are recognizing that the time is right for criminal law reform. The bad news is that the hard work of correcting this problem has not yet started. So I hope that criminal law reform can be done here in Texas so that it can become a model for other states to follow around the country. Thanks a lot for your attention.
Thanks so much, Tim. And I know you use that term regulatory crime, and just imagine most people here may be familiar with it, but in case you are, really that is zoning in on those types of crimes that are outside the penal code where there's not really an individual victim. It's like the crime in Texas for mislabeling fruit. It doesn't say that as an element of the crime the fruit has to be bad or somebody had to get sick. No, it doesn't matter. You mislabeled fruit. The victim is essentially the government, effectively, when it's regulatory crimes. And that's why it turns the traditional notion of crimes on its head when the government is protecting one of us from harming another person. And so, I think it illustrates the need to go back to focusing the criminal justice system on individual victims. Now, I also want to mention we have some guitar picks, Right on Crime, Don't Pick on Gibson guitar picks over on that table. You're welcome to get one of those as you leave. But we've got a great speaker now, Shannon Edmonds, who's Director of Government Affairs for the Texas District Attorneys Association. He's a former prosecutor, provides extensive training for prosecutors around the state, and he is called upon regularly by legislators for his expertise on the penal code as well as those criminal justice issues outside the penal code. So please join me in welcoming Shannon Edmonds.
Thank you. Excuse me while I do a little... Unlike Tim, I need some visual aids to help get my point across. I'm pleased to see some familiar faces. If you didn't recognize me, I know you always wonder what lobbyists do during the interims that we have in Texas. I decided to go undercover on the steps of City Hall and infiltrate Occupy Austin, so I had to grow a little facial hair. But those people don't use enough enough deodorant, so that didn't last very long. I'm pleased to be here, and what I want to do is focus a little bit on a Texas-specific analysis of this issue. Now, what Mark laid out is, criminal law versus free enterprise. What's the verdict? Well, I'm a former prosecutor who works for prosecutors, so naturally, I think the verdict is guilty. Who's guilty? Everybody's guilty. We'll let God sort them out later, right? In Texas, that's the narrative for prosecutors in Texas. Of course, that's a stereotype. But seriously, what I'm going to point out is I'm not going to give you the defense of criminal law and the defense of prosecution because both of these parties are guilty. And I'm going to explain to you why. First, let's talk about criminal law. Who makes the criminal law? The legislature. So if the criminal law is at fault, a lot of the blame lies with them. Here's a little quiz. I want to know how many new crimes you think the Texas legislature has created from 2001 to 2011. That is 6 sessions. How many new crimes the Texas legislature? But I'm sorry, sir, it's Jeopardy. In the form of a question, please. Yeah. 500. Anybody else want to take a gander?
About 6,000.
6,000. See, these are people who spend a lot of time around the legislature. It's actually not quite that bad. Since we started keeping track in 2001, the legislature has created, by our count, 249 new crimes. Now, these are not existing crimes that were enhanced. These are new sections of the law that were put into effect by the legislature to criminalize certain specific conduct. And again, like this session, there were 53 new crimes brought into existence by the legislature. They also enhanced about 25 existing crimes to raise the punishment for them. Now, 2 numbers here jump out that are, in 2009, only 40 new crimes were passed. Can anybody think why the number in 2009 would be low? What happened that session? Chubbing. Now, if you're not familiar with the Texas legislature, please, before you Google the term chubbing, make sure your safe search is on. But it was a delaying tactic in the House that reduced the number of bills that were passed regardless. So that's my explanation for the 40. Let's go up to 2003. Put on your Wayback Caps. Remember, what happened in 2003 that would have caused fewer bills to be passed? Ardmore, Oklahoma. The House Democrats busted quorum and killed hundreds of bills by setting up camp at the Holiday Inn Express in Ardmore, Oklahoma. So we just had fewer bills passed in those 2 sessions. But I want to point out one thing that we're going to talk about in a minute. There is a clear demarcation between 2003 and 2005. And I'm going to posit a reason for that besides Ardmore. Anybody remember what House Bill 4 was? By Mr. Nixon, does he still work for Tort Reform?
Yeah, he's not jumping up.
Tort Reform. What in the world does that have to do with criminal law? Well, cogitate on that. We're going to revisit it in a minute. But why should you care that the legislature is creating on average 42 new crimes every session? Well, as Tim already said, you may be the victim. Ignorance of the law is no excuse. Never has been. We even have a provision in the Penal Code that says so. So you may be, yes, question?
Yes, ignorance of the law is an excuse if you are an attorney employed by the government or a judge. It's called absolute immunity. And that is the reason why we have a lot of unlawful prosecutions, is because ignorance of the law has been decreed as an excuse if you are someone who the public pays to know the law. Then you can claim that you do not know the law and you can violate it with impunity.
I'm assuming you've been a victim of that.
Yes.
Thank you. As long as that doesn't count against my time, we're okay. But as Tim pointed out, you have people who find themselves in the criminal justice system without any criminal intent. There's another reason why this is a problem. And This is a slide from one of Mark's presentations. Mark, now you know why I never put my presentations online. Because I stole your slide. But I had no criminal intent. This is TPPF's, the Center for Effective Justice. These are some of their policy statements that they go by. And look at this fourth one. Don't use the criminal law to grow government. See, this is a problem. When you give the government something to do, it requires more government. So every time a new law is put on the books, it requires the government. Only the government can enforce criminal law. So what I don't understand is why we had a session full of people who are Tea Party devotees, who follow the gospel of Grover, who want to shrink government to the size that it can be drowned in the bathtub, and yet they turned around and passed more new criminal laws than any time in the past decade. There's a logical disconnect there, and I don't know if it's lack of education or what. But I do have one explanation for why this happens. Why politicians file bills to make things crimes. And it has to do with our 24/7 media culture. And here's my example for you. Casey Anthony. Why do all of you, does anybody not know about the Casey Anthony case? Why do you all know about some woman from Florida who killed her daughter, was acquitted of killing her daughter? Okay? She is the most hated person in America right now because of the news coverage. And as a result of what happened and the injustice that was perceived, people decided to take action. So this is from change.org. Anybody can go on there and create petitions. A woman from Oklahoma said, I want to put a petition and get people to sign on to Kaylee's Law that we're going to pass in all 50 states in the federal government. And it's hard to see it there, but in 2 or 3 weeks of being online, she had over 1.2 million supporters throughout the country. And when asked why she wanted to do this, she said, so that no more innocent children will have to go without justice. I mean, wouldn't that fit perfectly on a campaign bumper sticker? You see why politicians tap into this sentiment? And of course, what is she talking about doing? She's talking about requiring people to report dead kids within an hour and missing kids within 24 hours. And again, there's no culpability here. You don't have to have a criminal intent. It's just if you know about it and don't report it, you're guilty. And these are going to be felonies, according to Miss Michelle Dawn Crowder from Trailer Park, Oklahoma. And when CNN asked her, why did you decide this was the solution? She said, I don't know. I haven't talked to anybody in law enforcement. I haven't talked to anybody in policy. I just felt that something had to be done. That sentence is the cause of more bad legislation than any sentence in the English language. And by the way, I just want to say, if you think this is a good idea, you have to believe Casey Anthony is innocent. Because if she was guilty of killing her child, do you think having a law like this would make any difference? No. If she's going to ignore the statutes against murder, she's going to ignore these statutes. So if you think this is a good idea, it means you believe Casey Anthony is innocent. Of course, because of all of this groundswell support, legislators here in Texas were getting emails and phone calls and faxes saying, you need to pass this. And the smart ones, who I like, called us and said, what is the current status of Texas law? So I did a little research. I found 7 separate crimes on the books in Texas that Ms. Anthony could be prosecuted for if she had done this in Texas, assuming she gets away with murder, which I'm not saying she's going to do here. Even 2 felonies. And the top one was created as a result of 3 different crimes in 3 different counties in which suspected murderers got away with the crime because they damaged, destroyed, or tampered with the body to such an extent that there was not enough evidence to tie the suspect to the murder. So the legislature solved our problem. We won't have a Casey Anthony here in Texas. So what are the odds that Casey's law passes next session? 100%. Because this is logic and reason and common sense. And when you get constituents who demand something, whether it's good for them or not, legislators feel compelled to deliver on that promise. So that's why we have a penal code that started in 1993 with 160 crimes and now has about 225 crimes in the penal code. But again, remember, over the last 6 sessions, the legislature has passed 250 crimes. It's like adding a whole other penal code to Texas law just in the past 11 years. Where do all those laws go, by the way? That math doesn't add up, right? Well, they go everywhere else where nobody can find them. Our association had to create a book that we published to try to keep track of all the crimes that are not in the penal code, and it gets longer and longer every session. What you find is there are crimes in the Business and Commerce Code, in the Finance Code. There are 175 or so crimes in the Occupations Code governing business. And I know Representative Caligari is going to talk about some of the craziness in that area. It's silly. It is just silly, and it's not effective. Why does this happen? Well, remember what I'm talking about tort reform? When people have been aggrieved and feel they've been a victim of an injustice, if they can't get it from the civil system, which is something that I think tort reform might have contributed to, they're going to try to go to the criminal justice system. Even without tort reform, though, it's expensive to sue somebody. There aren't enough courts and venues. And if you're dealing with a business, frequently, there's just a Supreme Court case that came down yesterday mandating that certain consumers had to go through mandatory mediation rather than sue some credit card companies that they felt had wronged them. So there's barriers to getting justice in the civil system. But you know what a legislator can do? He can give that constituent a free lawyer. It's called a prosecutor. You see, victims don't have to pay anything for a prosecution because the government does it. What that means is that all of you pay for that victim's lawyer. So when you create more crimes, you are in a sense taxing yourself because you're paying for prosecution. One other cause of this has to do with my favorite quote ever from P.J. Rourke from the Parliament of Horrors, that when buying and selling are legislated, the first thing to be bought and sold are legislators. Now, if you haven't read the book, see, the whores are us. It's not Congress, it's not the legislature. We, the people, the citizens, are the whores. Because we've set up a system where when the government starts getting into business and picking winners and losers, business naturally defends itself by getting involved in the legislative process. And in this context of over-criminalization, one way that can happen is by erecting barriers to entry for your competitors, or punishing your competitors by creating criminal statutes that the government can use to go against them and not you. Isn't that slick? So these are some causes. Now, what do? We just get rid of all these bad laws, right? Well, it's not so simple. You see, you have to remember the first rule of repealing a law is the same as the first rule of taking down a fence. You have to know why the fence was put up before you decide to take it down. As this slide from a zoo shows, it's not always the reason that you think it might be for why that fence might be there. Maybe it's to protect the animals and not you. Let me give an example of this. Anybody want to live next to this? Of course not. Okay, little environmental law. These are 2 slides from an actual training by an environmental prosecutor. When you're talking about environmental enforcement, like Tim talked about earlier, you have every government under the sun who seems to have some kind of jurisdiction here, and there's different types of environmental enforcement, and there are different ways it can be enforced. Now look at these. Criminal has to be the government. Administrative has to be the government. Civil can be a private citizen or the government. Another example would be right now reading about the Attorney General suing Johnson & Johnson and some drug makers. Okay, that is a civil enforcement approach to regulation. At issue, $1 billion is at issue in that trial. But all of those enforcement approaches involve the government to some extent. Why do we have this? This is an actual slide that is the flow chart to determine whether an environmental enforcement action should be criminal, civil, or administrative. And if you are a fan of limited government, this hurts your heart. I mean, this is just a train wreck, isn't it? Why do we have this much government? Wouldn't it be simpler if, say, we just took all that stuff in yellow and got rid of it? Wouldn't that simplify things, shrink government, make it better for the free market? Absolutely. People who pollute would love it. Because why do we have 3 different enforcement mechanisms? It's because when we only had administrative and civil enforcement, it didn't work. It was the cost of doing business. And so people went back to the legislature and said, we need tougher sanctions, something that will be more than just a slap on the wrist. And that's why you end up with over-regulation. Oftentimes, it's because what was tried before didn't work. So I'm going to leave you with this. My time is up. I'm not going to give you solutions. I'm just going to give you problems. We're going to talk about that in a little bit, but, you know, we're never going to get away from legislating. I don't know what it says about our society that we seem to pass more and more laws every session, but I do know it's not good. Thank you.
Well, that was excellent. Thanks so much, Shannon. And we will have a Q&A session after our final speaker, which is Chairman Bill Caligari, who's head of the Government Reform Committee in the Texas House and has taken on this issue, particularly in the context of reforming our occupational licensing laws and trying to reduce the number and burden of those laws. And he is an engineer and businessman from Katy, Texas. Of course, he represents the Katy area in the Texas House. So please join me in welcoming Chairman Bill Caligari.
Thank you very much, Mark. I appreciate the opportunity to be here. I have to say, when I was first approached about being on this panel, I looked at it and said, you know, criminal law, I'm an engineer, I don't know anything about criminal law. I wondered why they might even be interested in what I might have to say about it, and then I realized that we had done quite a bit of work that relates to this overall subject. In fact, 2 sessions ago, let's see if I can, 2 sessions ago, we, my committee, the House Committee on Government Reform, looked into this issue of occupational licenses. We created 2 books about almost an inch thick that, you know, reported on the various occupations that we license and, you know, the issue of why we license them and the impact it has on, you know, on our government, on our citizens on a day-to-day basis. What we found out was very interesting, if not even alarming. When you think about it, that's particularly true for a state like Texas, as Mark mentioned earlier, that prides itself in less government. Excuse me, we actually, about 1/3 of the workforce is subject to some type of occupational licensing. As I said, it's very interesting for a state that prides itself in less government. So we'll talk about that and kind of look at what its effect is. This is an idea of some of the things that are regulated in Texas. Accountants, engineers, doctors, barbers, mortgage brokers, architects, dentists, pharmacists, etc. As you can see, as you look at the list, some of those you might say, well, you know, that probably does need to be some regulation for those folks. However, this is a very short list. This is a full list of all of the jobs regulated in Texas, and if you want to count them, there are over 500 licenses required for occupations in Texas, for somebody to work in Texas. Again, we pride ourselves in being a low regulation state, but we regulate more than in most other states. The national average for over the U.S. is about 28%. In Texas, we license over 1/3 of our workers, and again have over 500 licenses. That's you know, quite a chore when you really look at it. And we use this license as a way to basically protect the industries. And the list of occupations tends to grow each session. Over the last several sessions, we've added from 10 to 15 new licenses every session. We very seldom cut back, we add. And in 2009, the legislature voted to regulate about a dozen more types of jobs and businesses, including laser hair removal, dyslexia practitioners, and mortgage loan originators. During the most recent session in 2011, we regulated dog and cat breeders. In case you forgot, that was a big issue last session. And by the way, I heard today that some of our constituents think that's going to be a big issue in the upcoming primary, which was a surprise to me. We also voted to regulate athletic agents and eyelash extension applicators, really important industry. It's amazing when you start looking at the list, is how many things that are regulated that are just licenses that are required for things that you never even heard of. I can tell you 2 sessions ago, about 4 sessions ago, when the Tort Reform Committee was still fairly new, there was a move to combine barbers and beauticians together. And you would think that you were trying to take their first bar away, the idea of putting those 2 groups together. We did an analysis, and when you looked at all of the things that affected those 2 entities, there were a list of, maybe 100 or 200 items individual items that they regulated. There were 3 items that weren't exactly identical. Finally, a session later, they did combine them, and the world didn't fall apart, and none of those people lost their businesses. But it's amazing how much resistance there is to do anything that, in most cases, could improve the situation, but people just resist any kind of change, and that's a real problem. What does licensing mean? It certainly confers an ability or right to engage in a certain practice. It creates a new crime of engaging in practice without license, and I think that's a real problem, particularly with reference to the subject we're talking about today. And we have created several, hundreds of new crimes by way of new licensure requirements. When we regulate these licenses by applying occupational limitations on them, we establish an exclusive right to practice and protect the industry basically as being licensed. It's a barrier to more, barrier to more people coming into an industry, which in the long run actually reduces competition and costs the taxpayers more. We also, of course, create a new crime, that of engaging in a regulated practice without the required license. If you sit down and look at the chapters of law that created the licensing programs, many explicitly state that it's illegal to engage in a regulated practice without a license. They also prescribe penalties, both civil and criminal, for committing the crime of practicing without a license. Over the past 60 years, the legislature has created, as I said, hundreds of new crimes by creating these license requirements. Let me give you some examples of some of those, if you will. Oops. Here we go.
Take that menu away.
Yeah.
Sorry about that. First regulated in 1983, the unlicensed First regulated in 1983, the unlicensed practice of speech language pathology could land someone in county jail for up to 6 months and a fine up to $1,000. I don't know how many of you saw the Oscar-winning movie The King's Speech. It was about a speech therapist who assisted King George VI. The therapist was not licensed by the Crown. There's an interesting, if you haven't seen it, you ought to see that, but I guess you ask yourself, who's really endangered if somebody tries to help somebody who's not licensed, as this individual did for King George? Who's endangered, and whose life did you threaten by allowing them to continue the work they were doing without a license? This one hurts me just to look at. I don't mind doing a shot, but I'm not sure I want 1,000 pins in my head. But practicing acupuncture without a license is a third-degree felony. If somebody stuck therapeutic needles into your head or any place on your body, they'll get fined or could go 2 to 20 years. Without an acupuncture license. Now, you may say, well, maybe that has some merit, maybe they should be licensed, but I don't know if I'm crazy enough to let somebody stick 1,000 pins on me, maybe I deserve what I get. But on the other hand, obviously they do some good somewhere. Art therapy has to be licensed. Using the title of art therapist without a professional counsel license is a Class B misdemeanor. If I were to call myself an art counselor and invite you to draw a picture about how you feel, I could potentially be put in jail for 180 days. I'm not sure that's appropriate. There are many other licensed occupations for which individuals may be criminally prosecuted for practicing without a license. Here's a little more perspective than I do. The column on the left lists those occupations for which you may be charged with a Class A misdemeanor for practicing without a license. A Class A misdemeanor is 1 year jail penalty and a fine up to $4,000. For instance, in the eyes of Texas justice, an unlicensed court reporter deserves the same punishment as unlawful restraint or assault. Getting caught doing massage therapy without a license for the second time is the same as getting caught for second DWI or a prostitution offense. Processing shellfish without a license merits the same penalty as violating a family violence court order. And inspecting real estate without a license ranks up there with car burglary and perjury. When you look at those two, they just aren't comparable. But those are the things that we do when we create these occupational regulations, these licenses. Now, I really don't have a quarrel with the penalties associated with the criminal offenses. In fact, some of them should be maybe a little heavier than we see, but I certainly don't understand how the public's interest is served by requiring licensing for entities that really don't affect the overall public to any great degree. A lot of this can be solved by other methods, I think. Do you really want to make criminals out of honest people who are really trying to do a job or get into an industry? And maybe they do get into an industry they don't realize needs to be licensed. But the fact is that sometimes we make criminals out of people because they're just trying to earn a living. And I'm not sure that that's correct. One of the key problems that we have when we turn to occupational licenses to pick winners and losers is that we use occupational licenses to pick winners and losers in our occupations that we allow people to be employed in, and that's not right. That's not a good thing. We also collect fees that used to justify the existence of these licenses. One of the things that I find when I talk to people about this is that sometimes they justify the existence of these licenses because with the statement that, well, it brings more fees into the government. Well, my retort to that is that's exactly what we want to avoid. We don't need more government fees and penalties. We need less. We need less government involvement. The road to reform. Texas needs to take several steps towards fixing what I call is the licensing, occupational licensing mess. It's a real mess. Problem is, it's a lot easier said than done. If we don't, we will wind up with more regulations, the fees and taxes, penalties involved, and more bureaucrats and more agencies to enforce those regulations. As I said, some people justify their existence just by saying, well, it raises fees for the state. Well, the fact is that whatever fees they raise with the licensing fees are used to regulate the licenses, so it's a catch-22 and nobody gains, and I think the general public suffers in the long run. The first thing we need to do is critically reevaluate the criminal penalties associated with those licenses. Certainly penalties should be maintained for those occupations that do have a clear and direct impact on public health and safety. There are some things that we do need to have to protect the citizen. But criminal penalties for other occupations, especially those without health and safety nexus, could be replaced by civil penalties. as an alternative to continue the licensing programs or creating new ones, we should resume using the laws we already have on the books, such as those relating to fraud, theft, deceptive trade practices. Those laws work to stop the bad actors and can take the place of many of these occupational licenses, in my view. They will stop the bad actors, the fly-by-nights, the charlatans that the licensing programs are required or intended to sorry about that, guys. We need to eliminate those unnecessary licensing programs and really stick to our goal of, at least my professed goal of reducing regulation by the government. The past session, we stopped regulating talent agencies and personnel services because were no longer necessary. We had a list of a number of issues, licenses that we wanted to eliminate, but every time we tried to go into one, at various times when we tried to introduce them, we ran into roadblocks and found it very difficult. As you all of you have followed the legislature know, it's very, very difficult to undo something that's already been done. It's very difficult to take all legislation off the books. We keep trying, but it's difficult, and we need the support of people like yourselves who are active in the government to talk to the legislators that you know and make them understand that you really mean what you say when you want less regulation. We can't, as I think Shannon mentioned earlier, we can't say we want less regulation and then ask for more. We've got to stop somewhere. We can use, one of the things that I think could be done is we could begin to use private accreditation services who are capable of, basically the trade organizations to do their own regulation. They can have their own regulation. They can utilize not their regulatory, but their abilities to affect an industry by accrediting their organization, so that people will tend to use those that are accredited and not use those that aren't. And particularly with the advent of the computer, people can find out what they need to know about agencies, and all they need to do is go to accredited agencies and go to the internet, and they'll find all the data that they want about a particular industry and decide if they want to use them based on the recommendations they get from other folks. For instance, some of the examples that we've worked on, athletic trainers, for instance, could be licensed by the Texas Department of who are licensed by the Texas Health Services, could be certified by the National Athletic Trainers Board of Certification. They can serve a good job to do whatever needs to be done to certify those folks. Court reporters, likewise, who are licensed by the Texas Department of License Regulation, can be certified by the National Court Reporters Association. Almost every occupation, almost every industry has a trade organization that could serve to do the accreditation, the training, everything they need, and get it out of the government function. We really don't need those people in government. One of the reforms that we've looked at, in fact, I've presented it a couple of times. We've not been able to get it passed yet for various reasons, but is establishment of a sunrise review process, which basically provides some criteria that the legislature would look at to determine whether something needs to be licensed. And it's based basically on the issue of, the crux of it is, if it's not serving a need to protect the life and health of the citizens, then we probably don't need it. It's a list of 7 or 8 issues, that test, if you will, that you would apply. And if those tests aren't met, then we really probably don't need to be licensed, and it should go to some kind of a trade organization. I still have some hope. While we can never keep the legislature from introducing any kind of legislation that they may want to, even with a Sunrise Act, if you will, that would at least make them, induce them to review the criteria. Should I not create this new license? It would at least provide some guidelines so that, that we could maybe cut down on the number that we do. The things, I guess the 3 things I'd like for you to take away from this presentation is, one, that Texas regulates an extraordinarily large segment of its workforce, over 30%, 500 occupations, and affecting about 3 million people. Increased regulation has led to a real proliferation of new crimes, and in my opinion, it's moving in the wrong direction. It creates crimes by people who are, in many cases, trying to do an honest job. And number three, the long-term solution involves less government regulation and better reliance on free market and on laws that we already have on the books, such as deceptive trades and things that are already there that can be utilized by our enforcement agencies if they want to. You know, let's not create more agencies. Let's create less agencies. And move in a direction that gets smaller government, which I would hope most of you here believe in. Certainly, as a conservative Republican, I do. I keep working in that direction, but again, as I said earlier, it's very, very difficult to take something away once you start. But I do encourage all of you to help us where you can to work on the efforts of to both reduce the number of licenses and to stop the proliferation of these regulated businesses, less government for our citizens. Shannon said something I really like. I'll do a takeoff. He said, don't use criminal law to grow government. I say don't use occupational licenses to grow government, because that's what we're doing. Thank you very much.
We've got a little time here for some questions. We'll go there.
Yeah, another comment I'd like to make, and maybe the panel can respond to, is that my experience proves that it's not that our legislators that make the laws in our land of Texas. It is prosecutors and judges. And they make the law, and they make it up as they go along. And our legislators, who take an oath to preserve, protect, and defend our Constitution and laws, refuse to do so when presented with clear, unquestionable evidence that a judge or a justice has ignored the mandates of our Constitution, the mandates of our statutory laws, to deprive people of Texas of liberty and of justice. I was a business owner, a job creator. I clearly, unquestionably, was operating within the law, but nonetheless, my business was destroyed, my life was destroyed, my career destroyed by an unquestionably unlawful prosecution. Simply because a prosecutor wants to prosecute, and I found out the hard way that a citizen is not allowed to know the law. That's the worst thing you can do, is to point out the law. I know the law. I was a licensed real estate broker. I have to know the law to get a license, but you tell them the law and they take offense. And that encourages them to then prove to you that you cannot know the law and that they can violate the law with impunity and with immunity, and the legislature will not do a thing about it.
Well, can I just ask you, was it an individual district attorney or county attorney, or was the prosecution from the real estate board or the attorney general's office?
It was in Harris County, Texas. It was in 1993, and I have been through over 20 years of litigation, and the appellate court said what I'd said all along, that I owned the property that I was accused of stealing, and yet I never even had access to or control of that property, because the state, acting by and through the local prosecutor, took that property, claiming as their excuse that it was stolen funds. And the appellate court said what I said, that I was the owner of the property. I got a judgment against the state for unlawful imprisonment and for taking my private property, and the state still has not paid me a dime. So we have no private property rights in Texas, despite all the proclamations to the contrary. You have no private property rights. You have no liberty. The state and those who act in its name can do whatever they want. The media won't tell the public about it, because if they did, they would not be job creators like I was. They would not engage in free enterprise.
Well, let me
If I had known now, what I know then, what I know now, I would have simply gotten a job with the government, because then you are above the law and the rest of us have no protection.
Well, does anyone want to comment on, I'd be happy to get with you afterwards. Okay. Well, but we haven't, but I'd like to hear more about your case afterwards. You don't want to move on, though. Got a question back there.
I appreciate the presentation. Very fascinating. One of the things that I think was missing was the sort of effect of the war on drugs on our civil rights and the Fourth Amendment specifically, and the fact that while we talk about all these unnecessary laws and unnecessary regulations and prosecutions for people who don't know the law, it seems to me that there's not near as many cases of people being imprisoned for those sorts of things as there are for prosecutions for drug offenses, which Mr. Lynch pointed out the purpose of criminal law is for when you harm another. And so I was just wondering what your comments were on the war on drugs and its effect on our civil liberties.
Well, this is something we talk a lot about at Cato. I mean, people disagree on the subject. I mean, in our view, the drug war is kind of a revisit of alcohol prohibition. I mean, the number of cases that have come into the courts with drugs has totally swamped the system, and we're making a lot of the same mistakes that we made with alcohol prohibition. We're arresting a lot of people, we're spending a lot of money, but as with alcohol prohibition, people continue to use drugs. It hasn't stopped drugs from coming into the country. It hasn't stopped people from using drugs, haven't kept drugs away from our schools. What we get a lot of is a lot of crime and gangs attacking one another, and is people getting caught in the crossfire. A lot of corruption and curtailment of our civil and constitutional rights. I don't think we addressed it here is because the focus of this panel was specifically on how the criminal law is kind of getting out of control with respect to its impact on the business community in particular. That's why there's the emphasis on occupational licensing and some of these other problems that we've talked about with regulation and mens rea and that sort of thing. But it is a huge problem.
Well, we do have a panel at 4:40 today on traditional corrections issues, including which will cover drug sentencing reform and topics like that. Anyone else want to address that? The civil asset forfeiture, of course, also is most pronounced. I think most of those cases are involving drugs.
Right. I mentioned the hotel couple who owned the hotel. The guests of the hotel were involved with drugs, and yet it's the owners of the hotel that are having their property seized without any evidence of them whatsoever being involved in the drug trade. And to go back to the comment of the gentleman earlier, until it happens to you, it's just hard to impress upon you the costs involved of defending yourself when your rights come under attack. You could be pulled over on the side of a highway next week, and an officer might, search the car or may ask you may look in the contents of your purse or wallet, and if you have $500 or whatever, what do you do when the officer says, I think this is drug money? If you want it back, contact the state police. And the burden is suddenly shifted over onto you. You get your money back. I mean, and how many people, if they take you $2,000 away from you, you have enough of an incentive to go and fight, try to get it back. But if they take $50, $150, how many people are going to take a day off of work to go down to try to fight to get their money back? So the costs involved of trying to right or wrong are expensive. And again, until it happens to you, you don't realize the thin basis upon which property rights and other rights rest. So it's something to keep in mind, and it's why we want to keep the criminal law limited. We've all read about instances where people have been locked up wrongfully. The DNA test proves that somebody didn't do the crime. So we've got injustices that happen even with these core criminal offenses of rape and murder. So we want to keep so we know mistakes even happen within these core crimes. If we're going to expand the criminal code, then there's going to be more injustices. So to me, it's an overall reminder of why we want to keep the criminal code and government in general limited, because we know government makes mistakes, and one way of limiting those mistakes is by limiting government and keeping the criminal code limited.
Did you want to say something, John?
To follow up on the issue of civil asset forfeiture in Texas, and I'm not just saying it because he's here in the audience, but Lawrence Coleman, who works for Senator John Whitmire, knows that Senator Whitmire succeeded in finally passing a forfeiture reform bill that died from the chubbing in 2009. But it was a bill that was drafted with input from prosecutors and law enforcement and people who had been aggrieved by that process to try to reform and stop some of the worst abuses that we were seeing here in Texas. So we're optimistic that that's going to help limit some of the abuses that people have heard about, still maintain the original point of the program, which is twofold. One, take money from the bad guys, that is ill-gotten gain, hit them in the pocketbook, and two, lower everybody's tax burden, because we let law enforcement use the money they take from the bad guys. And if you get rid of that, just like taking down that fence, you have to know, why did we put it up in the first place, and what are we going to replace it with if we're going to take that out of the system? Because there are some law enforcement agencies and prosecutors' offices in Texas for whom the majority of their funding comes from asset forfeiture proceeds. And I'm not saying that's right, that's the best way to run the railroad, but that's how we do it. And if you don't fund it that way, you have to find another way to fund it, or you just have to do without a criminal justice system in those areas.
Do we have any other, dudes?
Mr. Calgary, I appreciate what the legislature's done with ex-offenders being able to get into some of these license areas that they weren't able to get into before. And my concern is you can still kind of look at that, because we've got a lot of people floating around out there that need jobs, and they all need to get into these professions that they were into before. And is there a way to just keep working on that to see if we can get them back into more professions?
He asked about ex-offenders getting occupational licenses.
Yeah, we'll certainly continue to look at that. I'd like to visit with you a little bit more about it, in fact.
Well, we are out of time here. I want to thank all of you for being with us, and we have evaluation forms. We have the Gibson guitar picks as well, and we look forward to seeing you hopefully in our corrections panel this afternoon at 4:40. We're going to have Jerry Madden, Representative Marissa Marquez, and many other speakers, Adam Gelb from the Pew Center on the States. So it's going to be a very good panel. I hope you can join us for that.